Testing 1 2 3, testing 1 2 3. This is Radio Free Mormon on the air, broadcasting behind enemy lines. Tonight's episode: did Jenn Kamp commit perjury? And I put a question mark after that, as well as an exclamation point, for a reason. And that's because that has not been judicially determined as of this point. However, there is a motion that has been filed by the trustee in the bankruptcy case in which Jenn is involved in Tacoma, Washington, where she filed for bankruptcy, that is tacitly alleging that very thing, that Jenn Kamp committed perjury. And that is the basis of a recently filed motion by the trustee in bankruptcy court to dismiss her case out of the court in Western Washington as being filed there improperly. But before we get to that, I want to follow up on the story that I last reported to you on the last episode. The last episode was released right before I went to Sunstone at the very end of July and the beginning of August of this year, 2024. In that episode, I reported that Jenn Kamp had filed a criminal charge of violating a non-existent stalking order against John DeLynn. And not one, but two Utah police officers bought off on this story by Jenn Kamp, this allegation, without bothering to check the court file to make sure that the no contact order, the anti-stalking order, was still in effect, which it was not. Once again, for those of you who may not remember what we talked about, it was almost 2 weeks ago, is that the allegation was that John DeLynn had violated the terms of a no contact order in November of 2023, when that order had been dismissed in March. Yes, in March, more than 6 months prior of the same year, 2023. So it had not been in effect for over 6 months. Jenn Kamp reported to the police that John DeLynn had violated it 6 months after it had been dismissed by Judge Coral Sanchez after a full 4-hour evidentiary hearing on the subject. And not only did Jenn Kamp get 2 police officers to buy off on it, she also got a prosecuting attorney to buy off on it. The charge was actually filed against John DeLynn. And at the end of the last episode, I predicted that John DeLynn's lawyer would pick up the phone, call the prosecutor's office, and let them know that actually an order had been entered in March of 2023, dismissing the very no contact order, the anti-stalking order that John DeLynn was accused of violating in November of 2023, and that charge would soon and summarily be dismissed by the prosecutor upon learning that somewhat, relevant information. So the first thing I want to do tonight is share with you the order that dismisses that case. Yes, I was actually correct in this prediction. Every now and again, I am right about such things. And here is that order of dismissal. You can see that in the upper left-hand corner, it has the name of the elected official, Sim Gill, the district attorney for Salt Lake County. And underneath that is the name of Dana Radford, who is the actual deputy district attorney who was handling the case and who did file her own motion to dismiss after being apprised of the fact that Jenn Kamp had not apparently given the police all the facts related to this particular allegation. You can see it's in the 3rd District Court of Salt Lake Department in and for the County of Salt Lake, State of Utah. It is the State of Utah versus John Parkinson DeLynn, and it is an order of dismissal in front of the Honorable William K. Kindle. It states, based upon the motion of the plaintiff, that means the prosecutor is filing this motion to dismiss, based upon the motion of the plaintiff and the interests of justice. Yeah, that's a phrase that you see a lot in these kinds of dismissals that can cover a lot of ground. It is hereby ordered that the information in the above entitled matter be dismissed, executed, and entered by the court as indicated by the date and seal at the top of the page. Okay, and up there at the top of the page, you can see it was dismissed on July 29th, 2024 at 3:30 p.m. Signed, William K. Kindle, District Court Judge. So that, as they say, is the end of that story. We will see if any criminal charges are forthcoming against Jenn Kamp for filing this false allegation against John DeLynn. By the way, let me tell you something about police, okay, and about prosecutors, because I used to be a prosecutor and I never was a police officer, but I've worked with police officers quite regularly, both as a prosecutor and as a defense attorney. And that is this: very shortly into an investigation, almost all police, not all, the very best will not make this mistake. The same thing with prosecutors, by the way. But almost all police will categorize individuals in their investigation as a victim or as a bad person or a defendant. In other words, a suspect, the person who did the wrong thing. The person they know did the crime, and they just have to get the evidence on them to prove it. So that happens very early in a lot of cases. In my experience, pretty much all cases, and certainly by the time charges are filed, if not at the moment the police arrive on the scene, actually. But as I say, a determination is made by law enforcement as to who is the victim and who is the criminal in a case, right? It doesn't matter that a jury has not made a determination on that. We don't wait upon such niceties when we are investigating crimes. So what happens is frequently this. Once you have determined as a law enforcement officer that a person is a victim, then that person will always have the status of victim in your mind. And once you have decided that another person in the same investigation is the bad guy, is the suspect, is the defendant, then that person will always be the defendant in your mind. And what this ends up leading to is this strange situation that even if you're a police officer whose job is to ferret out what really happened, and even if you're a prosecutor whose job is to prosecute the person who violated the law, that can sometimes get turned on its head. Because if it turns out that the person that you initially thought was the victim actually is the bad person, you may not be able to see that as readily because you've already determined that they are the victim. And if the defendant, the bad guy, ends up being the person who was actually wronged in a certain case, you're going to have a lot of trouble seeing that because you've already pigeonholed that person as the defendant, as the bad guy. This happens so frequently in my practice that I have come up with a saying for it. And the saying is simply this: once a victim, always a victim. The way that manifests itself is that after a person has been determined to be a victim, here, Jenn Kamp, it doesn't make any difference if that person is caught lying or being shady or slanting the truth. And the defense attorney points it out to the prosecutor. The prosecutor or the police officer will find themselves making excuses for this person because they have already decided that they are the victim. Therefore, anything that they say that's wrong or that is factually incorrect or that looks shady, that becomes defensible by them, and they will defend them. This is simply a mistake. They misspoke. They didn't understand the question, okay? Which is in stark contrast to how the same law enforcement officers and prosecutors will view a defendant who does the exact same thing. Everything that a defendant does that could look possibly shady or contradictory, that is ironclad evidence of guilt. If a victim does the same thing, then the victim is simply confused or mistaken or doesn't understand what's going on. I have seen this 1,000 times. So, under these circumstances, and the reason I bring this up is that because Jenn Kamp presented herself to law enforcement and the prosecutor as the victim in this case, and they already decided that she was the victim and that John DeLynn is the defendant, he's the bad guy, it is quite likely that they will never file charges against Jenn Kamp because they will end up taking her side and will end up defending her misstatement of the facts, her chronology, which doesn't make any sense, the fact that she misled the police. They will end up defending that as a person who was a victim who simply did not understand exactly what it was that she was saying. Whereas if a defendant, if John DeLynn had ever done anything like that, that would be evidence that he was guilty. So once a victim, always a victim. I am actually not, repeat, not holding my breath for these officers, this prosecutor's office, to pursue charges against Jenn Kamp for giving false information to the police. But who knows? Anything could happen, and maybe it will happen here. We'll wait and see on that. So that is the end of that particular story, at least for now, with the criminal charges that Jenn Kamp initiated against John DeLynn, got the police to investigate, got the police to refer to the prosecutor's office, and got the prosecutor's office to file charges against John DeLynn, which were dismissed within a week's time because the charge was baseless, it was groundless. The order that was alleged to have been violated had been dismissed after a full evidentiary hearing more than half a year earlier. So let's get to the next part of the story, because the next part of the story has to do with the question asked in the title of tonight's show: did Jenn Kamp commit perjury? Now we have to go from Utah up to Washington, Western Washington, where Jenn Kamp filed her petition for bankruptcy. And I have done a show about that petition for bankruptcy. But what has happened is this: the trustee, who has a great deal of power in bankruptcy court, there's a trustee that is assigned to every case, and they are there to manage things and hopefully shepherd it through the system and make sure that the laws are followed. And any repayment plan that is proposed is satisfactory under the law and is followed by the person filing for bankruptcy, in this case, Jenn Kamp. Well, what has happened here in bankruptcy court, and this is something that I have talked about behind the scenes for quite a few weeks now, though I don't think I've talked about it publicly, is that there appears to be an inherent inconsistency between Jenn Kamp's filing for bankruptcy in Washington and her filing for divorce in Utah. You remember that she filed for divorce. That divorce has also been finalized. The decree of dissolution has been entered as well. So let's start with this basic fact that Jenn Kamp filed for divorce in Utah. That divorce has been finalized with the decree of dissolution, and she has also filed for bankruptcy in Washington State, in Tacoma, not that far from where I live. The problem that Jenn Kamp is running into is that there are certain basic requirements for filing for divorce in a particular county in Utah, which she did. And also there are certain requirements for filing for bankruptcy in a particular district of the bankruptcy court in Washington, which she did. Now, these are not very complicated and they're not stringent requirements. They are very basic requirements, and they have primarily to do with: have you lived here long enough in order for you to qualify to file in this particular court? Does this court have the correct venue to allow you to file in that particular court? In Utah, the requirement to file for divorce is that you have to have lived in the county in which you're filing for a minimum of 90 days. That's 90 days prior to filing for divorce. Like I say, it's not that stringent. They are very basic, but they are very important. You cannot file in a particular court, or at least you're not supposed to file in a particular court unless you meet those requirements. So in Utah, you have to have lived in a particular county for 90 days minimum in order to file for divorce. In Washington, or in any other district, federal district, bankruptcy district, in which you may file, there is a similar venue requirement. It's stated a little bit differently, and here's how it's stated: that out of the past 180 days, you have to have spent the majority of those 180 days living in the district in which you're filing for bankruptcy, i.e. in Western Washington, which is what Jenn Kamp claimed when she filed for bankruptcy. Making this even more interesting and somewhat complicated is that Jenn Kamp filed for divorce in Utah and also filed for bankruptcy in Washington in such proximity to each other that she could not have lived in Utah for 90 days prior to filing for her divorce there, at the same time that she was in Washington State for 91 days prior to filing for bankruptcy there. So there was a conflict between her allegations that she qualified for venue in Utah for divorce and her allegations that she qualified for venue in Washington State. Because of that, the trustee has now filed a motion and set it for hearing at the end of this month, August of 2024. Today's date for the record is August 10th, 2024. I'm recording this Saturday morning. And in his motion for dismissal of Jenn Kamp's bankruptcy proceeding from Western Washington, he is bringing up this issue of venue. He is bringing up this issue of Jenn Kamp making conflicting statements about where she has lived and for how long in Utah versus those same kind of statements in Washington. And he has raised the specter of perjury. Yes, he has alleged that Jenn Kamp has committed perjury in one or the other. Now, he can't say exactly which one. He knows that both can't be true together. So he knows that one of those filings, either for divorce in Utah or bankruptcy in Washington, is based upon a false statement of how long she has lived in the jurisdiction. But ultimately, because the divorce petition in Utah has already gone through and has been signed by a judge with a final decree of dissolution, which includes the allegation that she had lived in Utah for 90 days prior to filing for divorce there, that now takes precedence because there has been a judicial determination on that issue, which means that that is going to be the one that is true. And if that is true, which it must be considered to be since there's already been a judicial determination on it, right? That she lived in Utah for 90 days prior to filing for divorce, then it must follow that she could not have lived in Washington for 91 days out of the 180 days prior to her filing for bankruptcy there. And that is the reason that the bankruptcy trustee has filed a motion to dismiss Jenn Kamp's bankruptcy proceeding in Washington, or in the alternative, if it's not dismissed, to remove it or transfer it to Utah where it belongs, because that's really the place that has venue over any bankruptcy proceeding that Jenn Kamp may want to pursue. And here is that motion filed by the trustee in bankruptcy court in Tacoma, Washington. You can see in the upper right-hand corner, it is filed in front of the Honorable Mary Jo Heston, who is the bankruptcy judge who is presiding in this case. It's a Chapter 13 bankruptcy. The hearing date on this motion filed by the trustee is August 29th, 2024. The hearing time is 1:00 p.m. in Tacoma, Washington. And the response date is August 22nd, 2024, which means that any response to this motion has to be filed by that date, 1 week in advance, at least, of the hearing date. So here's the title in the United States Bankruptcy Court for the Western District of Washington at Tacoma. It is titled Trustee's Notice and Motion to Dismiss or Transfer Chapter 13 Case to Utah, like I mentioned earlier. Notice, you are hereby notified that a hearing on trustee's motion to dismiss or transfer Chapter 13 case will be heard before the Honorable Mary Jo Heston at 1:00 p.m. on the 29th of August at the Tacoma Federal Courthouse Union Station, U.S. Bankruptcy Courthouse, 1717 Pacific Avenue, Courtroom H, Tacoma, Washington. If you oppose the motion, you must file your written response with the court clerk. Serve 2 copies on the judge's chambers and deliver copies on the undersigned and all interested parties, not later than the response date, which is August 22nd, 2024. If you fail to do so, the court may enter an order granting the motion without any hearing and without any further notice to you. Roman numeral 2, motion comes down Michael G. Malayer, Chapter 13 trustee, and moves the court for an order dismissing or in the alternative transferring this Chapter 13 case. Roman numeral 3, background. Jennifer Ruth Kamp, debtor, filed for protection under Chapter 13 of the Bankruptcy Code on July 5th, 2024. On June 11, 2024, just 24 days before filing her bankruptcy petition in the Western District of Washington, Jenn Kamp filed a petition for divorce, the divorce proceedings, from her husband, Jason Paul Kamp, Mr. Kamp, in the 3rd Judicial District, Salt Lake County District Court, State of Utah, the divorce court, and it gives the civil case number. A stipulation signed by both debtor and Mr. Kamp was also filed in the divorce proceedings on June 11th, 2024. A true and correct copy of the stipulation is attached here too as Exhibit A. Now, a brief aside, this entire divorce was done by agreement between Jenn Kamp and her husband, Jason Kamp. In other words, they agreed to all the terms of the divorce. And that is what the stipulation is. It's a stipulation or agreement between the parties, Jenn Kamp and Jason Kamp, that they agree to how everything's going to be resolved, how the property's going to be distributed, who's going to have custody of what kids, how much child support's going to be, how much alimony is going to be, all the details. that go along with getting divorced were all agreed to by both of the parties, and they signed off on a stipulation which they filed when they filed their petition for divorce, which is one of the reasons it was able to go through as quickly as it did. On July 8th, 2024, going back to this motion by the trustee's office was contacted by an attorney representing a creditor of debtor. I wonder who that was. Upon further investigation, trustee discovered that on May 5th, 2024, debtor had quitclaimed her interest in real property located in Taylorsville, Utah, the Utah home to Mr. Kamp. Oh, trustee found out she'd been quitclaiming property. That's a no-no. On July 15th, 2024, the divorce court in Utah issued its findings of fact and conclusions of law and divorce decree in the divorce proceedings. A true and correct copy of the divorce court's findings of fact and conclusions of law and divorce decree are here to attached as Exhibit B and Exhibit C, respectively. So the timeline is this. First off, on May 5th, 2024, Jenn Kamp quitclaims her interest in the family home to her husband, Jason. That happens first on May 5th, 2024. Then on June 11th, the following month, Jenn Kamp files for divorce against her husband, Jason, and they sign a stipulation agreeing to all the terms of the divorce. Finally, on the next month now, on July 5th, 2024, Jenn Kamp files for bankruptcy in Washington State, in Western Washington, in Tacoma, claiming that she's lived up there for the majority of the past 180 days. So that is the timeline here that is being laid out by the trustee. And finally, that on July 15th, 2024, the divorce court issued its final order, its decree of dissolution, ending that case and making judicial determinations, even though they're by agreement of the parties. They are nevertheless judicial determinations as to certain facts related to the divorce of Jenn Kamp and her husband, Jason Kamp. One of those facts being that Jenn Kamp had lived in Utah 90 days at least prior to her filing for the divorce. We'll get to that as well in a second. On July 22nd, 2024, debtor, that's Jenn Kamp, filed the balance of her schedules and a proposed Chapter 13 plan. So she's filed that through her attorney in bankruptcy court. Debtor's schedules state debtor transferred her interest. I'm just going to say Jenn Kamp here instead of debtor, okay? Jenn Kamp's schedules that she filed with the bankruptcy court state that Jenn Kamp transferred her interest in the Utah home to her husband pre-bankruptcy. The current market analysis indicates the value of the Utah home to be approximately $1,199,000. Jenn Kamp's Schedule D states that Mr. Kamp, her ex-husband now, holds a claim of $223,757 secured by the Utah home pursuant to an OLT lien. Debtor, Jenn Kamp, is the defendant in a multi-plaintiff defamation suit pending in the Salt Lake County District Court. Wow. I wonder how the trustee found out about that. He must be a very smart trustee. Nearly all of debtor's creditors, except for large corporate creditors, reside in Utah. Okay, so that's the factual background now. He gets to the argument. The Western District of Washington is not the proper forum for debtor's Chapter 13 bankruptcy case, as Jenn Kamp cannot satisfy the statutory venue requirement. For the statutory look-back period, and that look-back period would be 180 days prior to filing for bankruptcy, I believe. For the statutory look-back period, Jenn Kamp's domicile, residence, principal place of business, and principal assets were all located in Utah, not Washington. Accordingly, the court should dismiss Jenn Kamp's case, or in the alternative, transfer it to the bankruptcy court for the District of Utah, because it doesn't belong here in Washington. She doesn't qualify under the venue statute to file it in Washington, is what the trustee is saying. The trustee goes on in his motion, subsection A. Debtor cannot satisfy, or Jenn Kamp cannot satisfy the venue requirements of 28 U.S.C. 1408. In bankruptcy cases, venue is governed by that very statute. Under this statute, venue is proper in a particular district only if the debtor can establish that for the 180 days immediately preceding the commencement of the case, the district was the debtor's, and now there's 4 possibilities that can qualify for venue. That the district where it's filed was the debtor's number 1, place of residence, number 2, principal place of domicile, number 3, principal place of business, or 4, where debtor or Jenn Kamp's principal assets were located. So venue can be acquired by Jenn Kamp by meeting any one of those 4 categories. In Western Washington, was it where she lived? Is it her domicile? Is it her place of business? Is it where her principal assets were located? And ultimately, of course, the trustee is going to say no, 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 and get out of here. Whether venue is proper, he goes on, is determined by reference to the facts existing within the 180-day period prior to the filing of the bankruptcy petition. And then they cite to a case. If the debtor's domicile, residence, principal place of business, or principal assets were not located in one district for the entire 180 days, venue is proper in the district where one or more have been located for the longest period within that 180-day period. Debtor Jenn Kamp filed her bankruptcy petition on July 5th, 2024. Thus, under Section 1408, the relevant 180-day look-back period, and this is important, would be between January 7th, 2024 and July 5th, 2024. So July 5th minus 180 days is January 7th. So that is the look-back period, the beginning and the end of it, and every day in between. Debtor Jenn Kamp cannot establish venue in the Western District of Washington based on domicile or residence. Debtor did not reside in Washington during the statutory look-back period. Residence for purposes of venue is where the individual is physically present much of the time. However, the mere bodily presence of a person in a place by no means makes that place his residence for the purposes of venue. Residence means a permanent residence, one's home, as distinguished from a mere stopping place for the transaction of either business or pleasure. Although a debtor may have more than one residence, only one such residence may qualify for the purpose of establishing venue under the bankruptcy statute, the one where the debtor spent the majority of the 180 days prior to the bankruptcy filing. The primary consideration for residence is whether a debtor was physically present, living in the district for the requisite 91 days. 91 days, because that's the majority of 180 days, right? In the present case, debtor Jenn Kamp has not maintained a physical presence in Washington for the requisite 91 days prior to filing her bankruptcy petition. In debtor Jenn Kamp's divorce proceeding, Jenn Kamp stipulates that she had been a resident of Salt Lake County, Utah, quote, for at least 3 months prior to the filing of this action, period, end of quote. The stipulation also provides that Jenn Kamp's minor child who lives with her resided in Utah, quote, for at least 6 consecutive months immediately before the commencement of this proceeding, and that Utah is the home state of the child. And those are found in Exhibit A, pages 1 and 2. So let's go to those quickly right now, because those are very important facts. The trustee has attached 3 documents to support these assertions that he is making. Here is Exhibit A at the end of this motion by the trustee, and here is page 1 of that stipulation that's been referred to that was filed on July 5th, 2024, when Jenn Kamp filed for divorce against her husband, Jason Kamp. And as part of what Jenn Kamp alleged there, the very first line, grounds and jurisdiction, residency, petitioner, hereinafter Jennifer, has been a resident of Salt Lake County for at least 3 months prior to the filing of this action. That is the key. Here is where Jenn Kamp filed a document with the court in Utah claiming that she had lived and been a resident of Salt Lake County for at least 3 months prior to the filing of this action being the divorce action. Going back to the trustee's motion here on page 5, thus, Per debtor Jenn Kamp's own admission, between the dates of December 23rd, 2023 and June 11th, 2023, Jenn Kamp lived, resided, and was physically present in Utah, not Washington. So he gets that not only from the 90 days that Jenn Kamp alleged that she had lived in Utah prior to filing for the divorce, but also from other documents, including these, claiming that her one minor child lived with her for at least 6 consecutive months before the filing of this action, and also that Utah is the home state of the child. As such, the trustee continues, there exists no credible basis to conclude Jenn Kamp resided in the Western District of Washington for the requisite 91 days as required by the bankruptcy venue statute. Next section. Debtor Jenn Kamp was not domiciled in Washington during the statutory look-back period. So what the trustee is going to do is he's going to go through all 4 of those categories that can potentially give a person venue within a certain district to file for bankruptcy there, and show that none of these apply to Jenn Kamp. Debtor Jenn Kamp was not domiciled in Washington, not residence and not domiciled either. Similarly, he goes on, debtor Jenn Kamp cannot establish domicile in Washington. Domicile consists of actual residence and the intent to remain there. Domicile is one's permanent home, the single place where one has established a physical presence and demonstrated an intent to remain indefinitely. An individual can have only one domicile for purposes of legal venue. Domicile does not change unless and until a new one is acquired. Establishing domicile is a 2-pronged inquiry. First, the court looks to whether a debtor maintained a physical presence in a particular place for the longer portion of the 180-day period preceding the filing of her bankruptcy case. You can see how similar it is to residence. Once the physical presence requirement has been satisfied, which it hasn't here, by the way, once the physical presence requirement has been satisfied, the court then considers whether a debtor manifested an intention to stay in such place indefinitely. Physical presence is largely an objective inquiry wherein courts consider where a debtor resides as well as other objective facts such as the location of personal and real property, location of family, memberships, driver's license, and automobile registration, and payment of taxes. The intent inquiry includes a subjective as well as an objective component, although the subjective component may be established by objective facts. I think a lot of this is boilerplate. He's probably done this kind of motion before, and this is simply the legal background against which the facts of this particular case involving Jenn Kamp will be placed. When a person's domicile is in doubt, the inquiry generally involves whether the individual had the requisite intent to remain there. An individual's own declarations regarding intent are pertinent but not conclusive and should be discounted when inconsistent with objective facts. Indeed, the Supreme Court has noted that a declaration regarding intent for purposes of domicile is, of course, to be given full and fair consideration, but is subject to the infirmity of any self-serving declaration and may frequently lack persuasiveness or even be contradicted or negatived by other declarations and inconsistent facts. Here, Jenn Kamp cannot substantiate either prong of the domicile analysis. For the same reasons set forth above, as conclusively established by the divorce court, Jenn Kamp has not established physical presence in Washington. Throughout the relevant period, she lived, resided, and was physically present in Utah. Given that Jenn Kamp has not satisfied the physical presence prong, her intent is irrelevant and the inquiry necessarily ends. However, even if Jenn Kamp could show physical presence in Western Washington, she cannot establish that she intended to remain in Washington indefinitely. To the contrary, all objective facts indicate Jenn Kamp intends to remain in Utah. First, Jenn Kamp has no ties to Washington. Her employer is located in Utah, and Jenn Kamp works remotely. Likewise, as discussed in more detail in Section 2, Jenn Kamp's principal place of business remains in Utah. Utah is also where Jenn Kamp's child, over whom Jenn Kamp has primary physical custody, has a significant connection, and where substantial evidence concerning the child's care, protection, training, and personal relationships is located. Moreover, the stipulation and divorce decree both provide that Jenn Kamp will reside in the Utah home until it sells. In sum, Jenn Kamp's statements of intent to domicile in Washington should be wholly rejected when viewed together with Jenn Kamp's other declarations and the divorce court order. Next section, Section C. The doctrine of collateral estoppel precludes debtor from asserting venue based on domicile or residence. So the doctrine of collateral estoppel simply means that once you have litigated an issue in one court, it's over, okay? If you have the chance to fully and fairly litigate a particular issue, you don't then get to go bounce to another court and refile and relitigate the same issue. This is called collateral estoppel. It's also called issue preclusion. And this is done in order to give finality to courts' rulings. And so if I were to go to one court and get an unfavorable ruling, I might be tempted to go to a different court so I could get a more favorable ruling. That is what collateral estoppel is designed to prevent. It makes it so that once you get a ruling from a court, that is the final order. I mean, other than appeal, but that is the final order of the court. You can't go bouncing around from court to court and try and go forum shopping and try and get a judge who's going to give you a better result than the one that you got initially. So that's what collateral estoppel is about. The trustee goes on. Principles of collateral estoppel apply in bankruptcy. Under the Full Faith and Credit Act, the preclusive effect of a state court judgment in a subsequent bankruptcy proceeding is determined by the preclusion law of the state in which the judgment was issued. So they're going to have to look at what is the law related to collateral estoppel, issue preclusion in Utah, all right? Because it's Utah law on the issue of preclusion or collateral estoppel that's going to apply in the bankruptcy court, even though that bankruptcy court is in Washington. Here, the preclusion law of Utah governs. And by the way, I've looked at this brief, and it looks like this is the same as Washington. It's probably pretty much the same everywhere. In Utah, collateral estoppel prevents the relitigation of issues that have been once litigated and determined in another action, like I said, even though the claims for relief in the two actions may be different, okay? So this makes it a little bit more complicated. Even though the claims for relief in two different actions, they may be different, collateral estoppel can still apply to certain claims made within those two different cases. So the claim for relief in a divorce action is going to be to get a divorce decree. The claim for relief in a bankruptcy petition is going to be completely different. It's going to be to get a bankruptcy permitted by the court. Completely different causes of action. And yet within those completely different causes of action, there can arise the same issues. And in this case, the issue is that of venue. Utah courts will apply the doctrine of collateral estoppel when these four elements are met. One, the party against whom issue preclusion is asserted, that's going to be Jenn Kamp here. The party against whom issue preclusion is asserted was a party to or in privity with a party to the prior adjudication. Well, obviously she was. She was a party to the divorce, right? And she even filed. She's the petitioner in the divorce, which makes it even more difficult for her to wiggle out of this one. Number two, the issue decided in the prior adjudication is identical to the one presented in the instant action. And this is going to be one of venue and length of time living in different states. Three, the issue in the first action was completely, fully, and fairly litigated. And we're going to find that that's the case because the court in Utah has entered the final divorce decree, which means it's done, it's final, it's completed. The court in Utah has made a final determination on the issue. So that's number three. And four, the first suit resulted in a final judgment on the merits, which is what happened there when the divorce decree was entered in Utah. And then the trustee cites a case from Utah which explains if the same issue was finally resolved in an earlier case and otherwise meets the elements of issue preclusion, then further litigation of that issue is barred. You cannot relitigate that issue in a different court, even if the issue is a threshold matter of jurisdiction and does not go to the merits of the underlying dispute. That case is very applicable to this case with Jenn Kamp. Debtor initiated both legal actions, right? Jenn Kamp initiated the bankruptcy and she initiated the divorce. She filed for both. Jenn Kamp filed the petition for divorce on June 11th, 2024 in the 3rd Judicial District Court of Salt Lake County for the state of Utah. On July 5th, Jenn Kamp filed her Chapter 13 bankruptcy petition in the Western District of Washington. As Jenn Kamp initiated and was party to both legal actions, the first element of collateral estoppel is satisfied. Next, venue is a threshold requirement in both legal actions. Venue is a threshold requirement in Utah divorce proceedings. To file for divorce in Utah, the petitioner or respondent must be an actual and bona fide resident of the state and of the county where the action is brought. So not just the state, but the county as well. The statute mandates both actual and bona fide residency requirements. Most jurisdictions do not have our actual and bona fide residence requirement. Usually, actual is sufficient. Actual residence requires physical presence. The term bona fide resident connotes a good faith intention to reside in a particular place and is synonymous with domicile. Okay, I get it. Whether a person was an actual or bona fide resident has been informed by such factors as voting, owning property, paying taxes, having family in the area, maintaining a mailing address, being born or raised in the area, working or operating a business, and having children attend school in the forum. Thus, an individual must establish both domicile and residence in Utah in order to initiate a divorce proceeding. Venue is also a threshold requirement in bankruptcy cases. As discussed, a debtor may establish venue based on either domicile or residence. Residence requires physical presence, and domicile requires physical presence and intent. These requirements mirror the actual and bona fide requirements of the Utah Code. So even though the language is a bit different, the definitions of these terms are the same between establishing venue for bankruptcy and establishing venue for divorce in Utah. Accordingly, the second element of collateral estoppel is established. Next section, the issue of venue was fully resolved in debtor's divorce proceedings, right, with the final decree of dissolution. Jenn Kamp filed the divorce proceedings in the divorce court. In doing so, Jenn Kamp necessarily raised the issues of domicile and residence for purposes of establishing venue. As previously discussed, Jenn Kamp stipulated under penalty of perjury that she had maintained a physical presence in Utah between the dates of December 23rd, 2023 and June 11th, 2024, and intended to remain in Utah. As such, Jenn Kamp's stipulation establishes the third element of collateral estoppel. In Utah, the district court presiding over a divorce proceeding must make an independent determination that venue is proper. Such determination was made in this case. As set forth in its July 15th, 2024 findings of fact and conclusions of law and divorce decree, the divorce court determined Jenn Kamp satisfied the actual and bona fide resident requirement for Salt Lake County. The divorce decree is a final judgment on the merits with regard to Jenn Kamp's domicile and residence for the relevant period. Therefore, the fourth and final element of collateral estoppel is established. So you recall that in the stipulation that Jenn Kamp filed, she claimed to have lived in Utah for at least 90 days prior to filing for divorce. Exhibit B, which the trustee also attaches here, is the findings of fact and conclusions of law entered along with the divorce decree in that case. And he cites to page 2, so let's go there, shall we? Okay, here's Exhibit B, and Exhibit B is the findings of fact and conclusions of law on the divorce of Jennifer Kamp and Jason Kamp. You can see it was signed on July 15th, 2024 by the district court judge. And here it says at the bottom of page 1 of the findings of fact, which the court makes and is required to make in order to complete a divorce in Utah. Grounds and jurisdiction. Residency. Petitioner, hereinafter Jennifer, has been a resident of Salt Lake County for at least 3 months prior to the filing of this action. And even though this was signed on July 15th, 2024, the 90 days or 3 months referred to here have to do with the 3 months prior to the filing of the action, not the signing of the findings of fact and conclusions of law. But this is what the trustee is referring to. Not only has Jenn Kamp alleged that she lived in Utah for 90 days prior to filing for divorce, Now, with the final decree entered and the findings of fact and conclusions of law entered along with them and signed by the judge, that means there's been a judicial finding of that very fact that Jenn Kamp did live in Utah a minimum of 90 days prior to filing for divorce. Going back to the trustee's motion, the divorce decree is a final judgment on the merits with regard to Jenn Kamp's domicile and residence for the relevant period. In other words, it qualifies for collateral estoppel. This divorce decree has preclusive effect on any other judgment related to venue, including in the bankruptcy court in Washington. Therefore, the fourth and final element of collateral estoppel is established. Now, after having talked about residence and domicile, and then going through the analysis of collateral estoppel law in Utah and showing how, yes, this divorce decree and findings of fact and conclusions of law in Utah do have preclusive effect. They do meet the collateral estoppel requirements. The trustee is now going to go back to the remaining two ways that a person can have venue in Western Washington. Now, Jenn Kamp doesn't come anywhere close to having venue in Western Washington, but the trustee wants to be thorough and go through each of the elements, each of those four elements by which a person can have venue to show that Jenn Kamp does not have venue under any of these grounds. Washington is not debtors or Jenn Kamp's principal place of business. An entity's principal place of business is its nerve center, or the place where significant business decisions are made. Jenn Kamp's principal place of business is Utah. Pursuant to the Utah Division of Corporations, Jenn Kamp's business, Jennifer Ruth Kamp, LLC, entity number, etc., remains an active Utah limited liability company with a business address of 2246 West Surrey Road, Taylorsville, Utah. What's more, it appears the business license was last renewed on January 30th, 2024 in Utah. If Jenn Kamp had relocated to Washington on January 4th, 2024, as she claims, it is difficult to ascertain why she would choose to maintain the Utah business address. Finally, Jenn Kamp's LinkedIn provides that she is a social media manager, podcast host / podcast editor / life and spiritual coach, CLC, CSC, located in Salt Lake City, Utah. The principal place of business for Jennifer Ruth Kamp, LLC, and her other businesses has always been Utah. Consequently, Jenn Kamp cannot utilize principal place of business to establish venue in Washington. And finally, debtors' assets are not located in Washington. Courts have applied a context-specific analysis that construes principal place of assets in a way most resonant with the functional concerns of the administration of the bankruptcy estate, since all assets in question will be administered by a trustee serving under the jurisdiction of the forum court. Here, Jenn Kamp's only significant asset is her interest in the Utah home. Per Schedule A and B, which she has filed, the real property is valued at $1,104,000. On June 4th, prior to initiating the divorce proceeding, and within 90 days of her bankruptcy petition, Jenn Kamp transferred her interest in the Utah home via quitclaim deed to her husband. It appears Jenn Kamp may have transferred the real property in an attempt to evade numerous claims resulting from a defamation lawsuit against Jenn Kamp. The transfer would likely be subject to unwinding under 11 U.S.C. sections 547 or 548. And unwinding simply means that because it was done within 180 days of filing for bankruptcy, that's the look-back period. That is the period of time, the 180-day look-back period, during which people like Jenn Kamp are typically going to try and screw over the bankruptcy court and their creditors, by the way, by hiding their assets, by doing things like, quit claiming their interest in the family house to their husband from whom they're going to be soon divorced, right? Or even not soon divorced, but getting it out of their hands so that now their creditors can't come after them when they're filing for bankruptcy. That's why these look-back provisions have been on the books forever, Because this kind of manipulation and, frankly, abuse of the bankruptcy laws is so common and has been going on so long. And indeed, this is what it is that the trustee says it sure looks like Jenn Kamp is doing as well. Given the complexities of the claims against the real property and the fact that the real property is located in Utah, venue based on principal place of assets would be proper in Utah, not Washington. So, in other words, under all four of the categories that you can look at to determine whether venue is proper in Washington, Jenn Kamp fails all four. Washington was not debtor's domicile, residence, principal place of business, or principal place of assets, all four of those, during the relevant 180-day look-back period. Therefore, Jenn Kamp has not established venue under any alternative bases set forth under the statute. Consequently, venue does not lie in the Western District of Washington. Next section, and we're getting close to the end now. Jenn Kamp's Chapter 13 case must be dismissed out of Washington or transferred to Utah where it properly belongs. Section 1406 of Title 28 and Federal Rule of Bankruptcy 1014 govern improper venue in bankruptcy cases. Under the statute, improper venue must result in either dismissal or, if it be in the interest of justice, there's that phrase again, transferred to the district in which it could have been brought, i.e., the district where it actually had venue, i.e., Utah. Federal Rule of Bankruptcy Procedure states if a petition is filed in an improper district, the court may dismiss the case or transfer it to any other district if the court determines that transfer is in the interest of justice or for the convenience of the parties. Given that Jenn Kamp's own statements made under penalty of perjury indicate Jenn Kamp's domicile, residence, principal place of business, and principal assets were all located in Utah, trustee believes that transfer to the bankruptcy court in the District of Utah is likely in the best interest of justice and the forum most convenient for all parties of interest to the bankruptcy case. Dated this 30th day of July, 2024 at Tacoma. Signed, Amanda S. Douglas for Michael G. Malayer, Chapter 13, trustee. So there is the motion by the trustee in bankruptcy court to either dismiss Jenn Kamp's bankruptcy filing there or transfer it to Utah, where it should have been filed in the first place. Well, that is about all the news for now. We know that this is scheduled for hearing on August 29th of 2024, which is just 19 days away. We'll have to keep an eye on this and see what happens and whether Jenn Kamp's bankruptcy filing remains in Washington, which is looking pretty unlikely right now, or whether it gets simply dismissed or transferred to Utah, where it should have been filed in the first place. It is still an open question as to what on earth was going on in Jenn Kamp's mind and why it was that she filed her petition for bankruptcy in Washington, even though she had to lie in order to do so and say that she had lived in Washington for the majority of the past 180 days when clearly she had not done so. Is it simply that she thought that if I file it in Washington, that Utah won't find out and they won't know what it is I'm trying to do with quitclaiming the property to my husband? I have no idea. All I know is that this particular gambit on Jenn Kamp's part looks like it's about to meet its end, at least insofar as Washington goes, and it's going to be kicked back to Utah, where it should have been filed in the first place. Thank you so much for watching. Please hit like, please hit subscribe, please leave a comment below, and I want to thank all of my listeners who have taken the time to make a donation to Radio Free Mormon. Your donations do keep Radio Free Mormon broadcasting behind enemy lines. That's about all for tonight, folks. Until next time, this is Radio Free Mormon, signing off the air.